Well, hello, this is Mark from the Swamp School. I wanted to let you know about the recent Supreme Court decision that came out on May 31st. This is a really important one for those of you that do wetland delineations. The case was the United States Army Corps of Engineers versus the Hawks Company, and this was a case that basically upheld the Eighth Circuit Court of Appeals opinion that a jurisdictional determination is in fact a final agency action. And basically, what the court was reviewing was a thing called the Administrative Procedures Act and how it applied to jurisdictional determinations. The issue being is whether or not a simple JD without a permit would be considered a final agency action. And the reason they were looking at this was because of the costs associated with either getting fined and basically running into a whole bunch of problems with that, or simply applying for a permit and being denied. An interesting little statistic that the Corps had discovered, it was released at least through the courts, was that an individual permit on kind of an average basis, one study had found that the average applicant will spend 788 days and $271,596 to complete the process, and that is for an individual permit. For a general permit, better known as a nationwide permit, but generally that's what we're looking at, an applicant would spend about a year, 313 days, thereabouts, and $28,915 to complete. So both of these permits, whether it be an individual or a general permit or nationwide permit, are expensive to obtain. Now, the problem basically was with this particular case, getting into the facts of the case, was that the respondents, which was the Hawks Company, owned a piece of land and it did include wetlands. The question was whether or not the wetlands were considered jurisdictional or not, because of the issue being they needed to get a permit to discharge dredge or fill material into navigable waters. Well, the Corps had basically said that they would require permits and that the estimate for these environmental studies that were needed were going to be in excess of over $100,000. So this was a big expensive project. The problem is that the Hawks Company did not feel that the site was jurisdictional on the basis of the significant nexus issue of the site being more than 120 miles away from the Red River of the North, which is the nearest navigable waterway. So essentially they were disputing the need to get a permit because they did not feel that their site was jurisdictional. Even though it would probably be considered to be a wetland, it was a question of whether it was a jurisdictional wetland based upon the distance. Now, a couple things that came out of this case, and actually one of the problems with what came out of this case was they actually didn't get an answer as to whether their site was jurisdictional or not, just simply that they could sue. And that was essentially what it came down to. But a couple things that came out of this was what they called an affirmative JD and a negative JD. And this is in core parlance. The negative JD basically means is you don't have wetlands on your site. Well, what the Supreme Court had acknowledged essentially is that a JD will generally bind the Corps for up to 5 years. Now, there are some reasons why that may change, but basically it binds the Corps for 5 years. And the court has dubbed this a 5-year safe harbor time. So basically, if you have a project and you submit a JD, the Army Corps of Engineers and the EPA cannot basically come after you in this 5-year safe harbor period unless there's some new information that has come up. But basically, the government's position on federal action or litigation concerning this determination is sort of put in a bind. So the idea is that you have a 5-year safe harbor. So that is kind of an interesting event and basically underscores the necessity and the quality of the wetland delineations being done. But both JDs narrow the field for potential plaintiffs and limits their potential liability. Now, when they say both JDs, are referring to the preliminary and the approved. Now, the preliminary is really a non-binding one anyway, but the approved JD is primarily what they're looking at, and it essentially limits the potential claimants' limits for liability. So this is all related to a negative JD. An affirmative JD also has legal consequences, and essentially one is it represents that there's the denial of a safe harbor, so that the negative JDs afford. And then essentially of these legal consequences, the court had found that this is an issue basically giving reason for why this would be considered a final agency action. So the affirmative JD actually establishes where the wetlands are, and essentially, and can JD, meaning jurisdictional determination, establish where the wetlands are on a legal basis, and therefore it is a final action, and basically everything else flows from that approved JD. And that is essentially where the court had taken this from. Bennett, in this case, was one of the cases that they cited back in 1997. Now, the Corps, I mentioned this before, may revise an approved JD within the 5-year period based upon new information. That possibility, however, is a common characteristic of an agency action, and this does not make an otherwise definitive decision non-final. So, essentially, if the Corps wants to revise the approved JD, they have to go through a process, and USACOE was one of the cases that we were kind of dealing with on this. But the idea basically is that there is a possibility that an approved JD may have some new information and new interpretation, especially if it's a negative JD, and now we have some new information. But again, that safe harbor may protect the applicant. Now, there is basically, essentially, a couple things that the court was looking at, and one was basically the alternatives that the Corps put forward to the court. One was basically simply to let the applicant do whatever it is they're going to do, and if it turns out that they're wrong, they'll go to jail. And that was not really a great alternative, and the Supreme Court did not agree with that either. They basically said they need not wait for enforcement proceeding, and the specific view was that respondents need not assume that such risks while waiting for the EPA to drop the hammer in order to have their day in court, meaning that the EPA is now suing them. So the idea basically was that the applicants should not have to go through that process, and they should be able to challenge a decision, especially in light of the fact that we're looking at fines in excess of $37,500 per day that they violated the Clean Water Act. Now, it is also, the court had determined, not an adequate alternative for the Administrative Procedures Act review for landowner to apply for a permit and then seek judicial review in the event of an unfavorable decision, meaning they didn't get the permit. Basically, as the Corps officials had indicated in their discussions with the respondents, the permitting process can be arduous and expensive and very long, and the idea basically is that it's often used to keep people from applying for permits because they basically take too darn long. So the idea is that is another reason why the permit process is far and beyond what you would need to just establish whether or not the site is jurisdictional or not. So basically, the court had come up with one final issue here, and the Corps had one final issue, which is something to be aware of, which is the Corps had adopted a practice of issuing standalone jurisdictional determinations upon request. They're actually not under any obligation to respond to that, at least in my humble opinion. They do not have to issue a JD. There's not essentially a mandate that they must issue a JD. They do it upon request. And had the Corps never adopted its practice of issuing the standalone jurisdictional request, then we wouldn't be in this mess right now. And the court agreed with that, but they basically said such a count your blessings argument is not adequate, essentially, to rejoin the assertion of the right for judicial review under the APA. So the issue is, at this point, it is so ordered by the Supreme Court, and it was a 8-0 decision, and I will flip over here. We had an 8-0 vote, meaning that all of the justices sided with essentially the Hawks Company. The way that it reads is basically that the opinion was that the jurisdictional determination is in fact a final agency action and is subject to judicial review under the Administrative Procedures Act. And it was affirmed 8-0 in the opinion. It was filed again on May 31st. So while that may sound like a rather esoteric and kind of, okay, so what? What does that mean? Well, there's a couple things. JDs can go to court. They can go to court proactively, meaning that if you have a project that you basically want to apply for a JD, the Corps says they don't agree with your wetlands, or you think there are no wetlands there, and you disagree, and you go back and forth with basically up till this point, what the Corps said was the final rule. Well, now, because they can go to court, you now have to make sure that your data is up to snuff. And essentially, in legal terms, and I should caveat, I am not an attorney, I don't play one on TV, and this is simply for entertainment purposes, but field data is prima facie evidence. The idea basically is that field data is essentially the evidence in the field, but the evidence basically may actually be refutable. And the idea basically, prima facie evidence means that you have enough evidence to prove something by pointing to some basic facts, better known as soils, vegetation, and hydrology, but that your proof can be refuted. And that's an important point because we go into the concept of garbage in, garbage out. And we have a major Achilles heel in the wetland delineation business related to some of this data and how it's handled. And it's been something, if you've joined one of our classes, we've been harping on for years. But the problem is what's done. Well, now the issue is if you were to go to a judge with this data, you would want to make sure that your data is up to snuff and is going to hold up to legal scrutiny. And that is a huge concern. What data am I talking about? I'm talking about the plants. So the plant problems. What are the plant problems? Basically, the current method for establishing hydrophytic plant communities is to do an aerial estimate, which is nothing more than a visual estimate of percent cover from one plant species to another. Now, there are several places that you can find error in this process. One is the plant identification itself, but we'll make the assumption that you all know how to identify a plant and that you know the genus and species and you've been able to correctly identify it. And most botanists can do that pretty accurately, and most wetland delineators can do that pretty accurately. The problem is the estimate of coverage is highly variable. And we have seen in excess of 70% error. When we take a group of people out and we look at the same data and we compare data from one group to another, there's as much of a 70% variance from one group to another group on the same site. That's totally unacceptable as a procedure. It is totally unacceptable, but it is what is being done every single day, and it's being done under the understanding that, oh, well, it's quick and easy and whatever. Well, the problem is it's a high degree, and it's basically garbage. What we're talking about is percent cover of tree, and we know how much red maple, how much sycamore, and so forth, and these are all just guesses. Well, we can't have that if we're going to court. Quite frankly, we can't, because the Corps comes in and you've got your set of data and the Corps has another set of data and you've got a 70% variance between the two. Good chance the whole thing's going to get thrown out. So that is a big problem. Or you're going to look foolish if the Corps has done something else, which they're likely to do, as this method has already been approved and it's buried in the regional supplements, which is known as a point intercept sampling procedure. It's in Appendix B of every single regional supplement that's been published. It has already gone through the public vetting process, and it is an acceptable procedure. It's used quite extensively in the forestry industry. The nice thing about it is that the average is less than 2%, which is well within the realm of acceptable error. And it's in some cases even less than that. But basically the average is less than 2% error, and a point intercept method is a very highly precise method for estimating vegetation. Now, before you freak out and say, oh my gosh, this is going to add all kinds of time and effort to the project, we've actually done some additional studies to see basically doing the current method, which is breaking the site up into the various strata, going through the different tests, the dominance test, prevalence index, and so forth, and then running all the math. This method is actually faster and the data is better. So I don't know why we haven't been doing this all along. We seem to have spent a lot of time doing soils work, and we've done a lot of stuff with hydrology, and the plants just sort of were just kind of left there. Well, the Corps did leave it in the manual, so this is not introducing any new procedure that the Corps is going to have to approve. They've already approved it. So the upshot of it is you need to learn how to use it, and that's where we are here to help. The Swamp School has put together a series of live workshops. We're going to be offering these in various parts of the country, and essentially these are field procedure exercises. We've developed a set of data forms based upon the Corps method so that we can use their formulas and their math and basically make it very easy for you to collect the data. We also provide this thing called a densiometer, which is the tool used, which was that little white-looking pipe thing that we basically have for measuring the vegetation. We have lots of classes scheduled. We're working on more. There's been a huge demand for this, and we want to make sure that you are using and providing data that is top-notch and that would be able to survive, your day in court. So stop by the swampschool.org website and you will find dates and locations of various classes. If you have any question about the methodology, just drop us a line. We'll be publishing more information about it and making these things available to you. Actually, they are available to you now if you just like to purchase one. So at any rate, have a great time with this, and we'll see you back out in the swamp. Take care.